areas of estate planning. So most of the people who signed up for this are from New York. I'm going to give a New York slant to the presentation, but where appropriate, I will mention other states and, we'll give you a general idea what goes on in other states as well. Steve, you got to allow me to share. It's disabled at the moment. All right, well, until you do that, I will begin. So what we're going to talk about initially is what tools do you really need in order to do your estate planning? Well, there's certain basic tools, no matter where you're located, that you will need. First is a power of attorney. Second is a healthcare proxy. A third is a living will. And then the last is a funeral directive. Those are things we all should have while we're alive. And obviously for when you pass away, you should have a will. But where do trusts fit in? Well, that really depends on the circumstances. And we'll go into that. So we'll discuss these tools needed, namely power of attorney, as we said, healthcare proxy, living will and funeral directive. Then we'll discuss wills and trusts. And then we will discuss basic Medicaid planning. What that involves is how you are able to plan in the event you or a loved one has to go into a nursing home for long-term care. Next, we'll try to discuss protecting your principal residence. And finally, we will get into gift and estate tax. Steve, how are we doing with the sharing?
Yeah, can you hit the share button on the bottom of your screen?
It says you disabled it, so you just got to enable it. Okay. Click on that and enable sharing.
Hold on 1 second.
So just to give you a little overview, why I got into this. When I was a young attorney, I was a prosecutor in the Bronx DA's office. And my mom, quite frankly, was sick for 7 years before she passed. And we had to visit elder law attorneys and go through various things as a family. When I decided to open my own practice, I said, well, this is something that I'm going to, I went through, other people are going to have to go through. So
okay, you're up, Joe.
You can imagine what I went through. So I know for those of you who have a similar circumstance, you want to have some knowledge as to what to do and who to deal with. This is a very complicated area, but at least what I hope you leave here with is say, oh, that's something I need to think about, or that's something I need to do. And go back and refer to the outline and call an attorney and get your plans in order, and don't wait till it's too late. So this is the outline. As I said, we're going to talk about the tools for decision-making. We're going to talk about wills and trust. We're going to talk about basic Medicaid planning, protecting your residents, providing for your grandchildren or children's education, and some basics on gift and estate taxes. All right. So what are our major concerns? Well, we want to, number one, manage during the event of a disability. Right? We want to have someone available to make our healthcare decisions for us if we can't. And we want to know the consequences of asset transfers. When people say, oh, I'm going to go into a nursing home, giving everything away. Well, that may or may not be a good idea. And we'll talk about that. Your assets passing on death, are they going to pass as you intend? And that's also something that people have problems with. So, and of course, estate taxes, which quite frankly are not as big of a deal as they used to be, but we'll go over that. Well, let's talk first about a power of attorney. What does that do, right? Power of attorney allows you to give someone the power to handle your financial affairs in the event you can't. And it's a very powerful tool, but remember, it only relates to financial matters in New York. Some states are different. They put together various documents or various powers in one form. In New York, we don't. They're divided up. So the financial one in New York is the power of attorney, right? And well, when does it become effective? Basically, it becomes effective when it's signed and when the agent signs it. What do I do with mine? I normally suggest that you name two people as your agents, two people who can handle your finances, and a third person who could only step in if those two people cannot. Now, remember, as soon as you are, I know I stopped sharing the screen for a moment. So as soon as you sign that power of attorney, you give someone the power to manage your affairs. Some people don't like that. They're like, well, wait a minute. What if this person's going to steal my money? Well, here's my answer to you. Number one, pick wisely. Number two, there is something, at least in New York, I don't know about other states, that we call a springing power of attorney, which only takes effect if you're disabled. So he goes, oh, great, I'll take that. You know what? I will not draft that. Here's the reason why. Think about it from a practical term. Number one, you now become disabled. You have this document that gives someone the power. Then have to go to your bank or a brokerage account or wherever and prove that you're disabled. How are they going to do that? Well, they're going to need a letter from a doctor. Do you think doctors really want to prepare such letters? They don't. And even if they do, they're in the proper format of the financial institution, who knows? So I tell people, let me prepare the document, deliver it to your financial institutions, they may require your agent to sign something, have them sign it, have it all there so your agent can act. But what if your agent does something wrong? Well, wouldn't you rather know that where you're competent in catching them and you could put a stop to the power of attorney because you could cancel it at any time? I'll tell you a story that I heard from a colleague. This woman, not married, no children, lived in New York County, Manhattan, and she had to go in for some surgery. And she said at that point, well, I'm going to do some estate planning. So she named her sister, and who also happened to be her best friend, as her agent. And then she went in for some surgery, and she basically was out of commission for about 4 weeks. When she finally regained her faculties and went online, she found that her sister took $40,000 and blew it in Atlantic City. So do we want that? No. What if she was competent when she'd given the sister the power and the sister had taken some action? She could have stopped it right away. And also, I think psychologically, if someone knows they have the power for a long time, they're not going to really abuse it. I just think that's psychologically how people work. So you are giving up a lot of power. I tell clients, look, you're signing this power of attorney, your son, your daughter can take all your money and run away to Bolivia if they want, and they can. But remember that agents under a power of attorney are under the highest fiduciary standards, and they can be and have been criminally prosecuted for abusing their powers. So I think it's a good idea to choose your agent wisely and give them the power. Now, some people think that after someone dies, they could still use the power of attorney. No, that's not the case. The power of attorney ends on death. So it cannot be used after death. So once again, manage your financial affairs, use while you're alive. You can cancel it at any time, okay? Looking at the outline, most of this we covered. You're granting someone authority to act for you, right? It can be limited or broad. The power is, but I make mine very broad. I give someone the same power you have. The only exception to that is sometimes in real estate transactions, if someone can't attend a closing and they want to give either me or someone else the power to handle a closing for them, that's when we make it limited. If not, I recommend being as broad as possible. Right? This year, June 13th, New York State enacted a new form power of attorney. So people ask, well, what about my old power of attorney? Is it still valid? Yes, it is. If it was signed before June 13th, it's valid. There was also a major change in 2009 and 2010. Now, as a practical matter, If you have a power of attorney from 2008 and it's been sitting in your drawer and you never gave it to a financial person, well, if your agent 3-4 years from now needs it, you're going to have a problem. So what I would tell you to do, if you have an old power of attorney and you haven't given it to the financial institutions, do so. They may want you to draft a new one. Technically, they're not supposed to, but you have people who are looking at things and they know it's valid now. The law is, as long as it's valid at the time it was executed, in the state it was executed, it should be recognized. Does that work as a practical matter? Always? No, it does not. Now, some people might ask, well, wait a minute, I drew up a New York power of attorney and I moved to Florida. Once again, the state of Florida, they're supposed to recognize it as long as it's valid in the state where it was drafted at the time it was drafted. But once again, as a practical matter, you might want to get another power of attorney drawn in Florida, just for practical reasons. There's the legal and the practical, and they sometimes don't always mesh. All right. As I said earlier, goes into effect immediately, can be revoked at any time, automatically revoked on death. What are the disadvantages? Well, obviously, the advantages and disadvantages are like two sides of a coin. Advantage, some power can act immediately. That could also be a disadvantage, right? The effect of a cancellation can be problematic if you don't provide proper notice. So the agents are required to sign it before it's effective. Another problem that comes up, what if more than one power of attorney is executed? Well, generally speaking, unless you specifically revoke a power of attorney, it's in effect. So if you have executed a power of attorney and you don't want that power of attorney in effect, merely signing a new one isn't going to help. You have to revoke that one, send notice to the agent, send notice to whomever you've given it to, and that's the way you revoke it. Right? There's something called an affidavit of full force and effect. I mean, I put it in my powers of attorney and people say, should I fill this, have my agent fill it out now? No. Every time the agent uses the power, they're supposed to fill out an affidavit of full force, which basically says, one, the principal's still alive because, as I said, it ends on death. Two, they haven't revoked it. Three, you see no reason why it can't be used. So that's the affidavit of full force and effect. So to summarize, power of attorney only relates to financial matters, goes to effect immediately upon being signed. You can revoke it at any time. It ends on death. Those are the basics of the power of attorney document. As I said, in New York State, it only relates to financial matters. In other states, they put it together to do other things, which now we're going to dovetail into. Healthcare Proxy, Living Will, and Funeral Directive. New York has 3 separate documents from those, 4 those, I should say. In other states, New Jersey is similar. Other states have them all in one document. I know for a fact Colorado has them all in one document. Depends on where you are. But in New York, it's separate documents. In New York, the Healthcare Proxy is statutorily the operative document under our general obligations law. And what does it do? It goes into effect when you cannot make your own medical decisions, okay? So as soon as you're deemed incompetent to make a medical decision by a medical service provider, your proxy can now make medical decisions for you. Right? So look at the contrast with the power of attorney. Power of attorney goes effect immediately on signing. Healthcare Proxy does not. Power of attorney relates only to finances. Healthcare Proxy relates only to medical issues, right? Can both be revoked? Yes, at any time. Another thing you should consider, New York State presumes that everyone wants life-saving means, artificial nutrition, hydration, no matter what, okay? And there's something called a do not resuscitate order. Now, a do not resuscitate order is an order signed by a doctor that says do not resuscitate. If this, but What happens if someone's in a hospital and their breathing is just fine, but they're brain dead? Okay. Well, if they haven't signed a healthcare proxy, they have to be continued to be supported. It's only if they can no longer breathe that they can let them pass away. So don't get confused. Do not resuscitate order is something signed by a doctor in the hospital related strictly to resuscitation. Healthcare proxy gives someone the power to make medical decisions for you. Now, somehow healthcare proxies say, my agent, my healthcare proxy knows what I want. I don't like drafting them that way. I like drafting them in conjunction with a living will. Now, what is a living will? It is a declaration or a statement that says, basically, look, if I'm brain dead, pull the plug. No food, no water, just give me drugs, no pain. Other than that, pull the plug. And I take the language from the living will and also put it in the healthcare proxy. So they're consistent. And my healthcare proxies and living wills have been honored by numerous hospitals. As I said, there's a statutory form. Sometimes hospitals like, here, fill this out. Well, they're okay, but I find a lot of people don't put their specific needs. They mess up the form. They also don't put a successor agent in, which is very important. If you're naming your spouse and you don't name a backup, which I usually name two, what if your spouse is incapable or your spouse is predeceased you, then what? It's useless. So once again, have a backup plan, have a backup in the document. Funeral directive, very simple. We allow this in New York. It allows someone to make your funeral arrangements for you. That's particularly relevant if you have no children, maybe you have no close relatives and you want to name a friend to do that. Gives them the authority to do that. So pretty important. All right, now we're going to talk about wills and trusts, okay? And let's talk about first, this is very, very important. And I want you to focus on the language in bold. The will only controls assets that are in the person's name alone. What does that mean? Well, just what it says. It has to be in your name alone. You say, well, you know, I have an IRA and I name my wife as my beneficiary. Is that in my name alone? No, it's not, because you have a designated beneficiary. Well, I have a bank account that's POD, pay on death. Is that in my name alone? No, because you have a designated beneficiary. I have a bank account that's joint. Is that in my name alone? Absolutely not. I have my deed joint. Is that in my name? No. Okay. It's assets in your name alone, meaning you're the only name that appears on the document. Here's an exception to that. A deed can have two names on it. All right. If the person on the deed with you is not your spouse, it is assumed that you own that property as tenants in common. What does that mean? You each own half. So if you own a property with your brother and it doesn't say things like joint tenants or right of survivorship, well, you own half the property, your brother owns half the property. When you die, your half goes to your estate. When he dies, his half goes to his estate. If the deed said joint tenants or right of survivorship, then the last one of the two of you gets the entire house. A lot of people don't understand that, particularly when it comes to real estate. Extremely important. So once again, going back to the will, okay? The will only controls assets in your name alone with no joint account designation, no beneficiary designation, no in-trust for designation, nothing but your name, okay? So I said the only exception is tenants in common asset, which is usually real estate. There could be other things that are tenants in common, meaning I own my half, you own your half, but the most common one is real estate, okay? So people say, well, you know, I wrote a will and what if I sell my house? No, so what? But I put my address in it, doesn't matter. Or I have 15 shares of IBM stock and I wrote them in the will. Well, I wouldn't recommend doing that, but the will doesn't take effect until you die. And if you leave, let's say you left an asset and you no longer own it. I leave my 15 shares of IBM, it's sold. Well, that's called a lapse. It drops out. It's like it's not there because the asset's not there. So what I usually do is I recommend that people do in their wills percentages and specific amounts. All right. Now, when you do specific amounts, they take precedence. And this is the other reason why you have to be consistent. Your estate plan has to be consistent because remember, joint accounts, they go as the account says. For example, if you wrote a will and says, I leave everything to my cousin Louis, but your primary asset is a bank account and I'm joint on the bank account, guess who's getting the money? Me or your cousin Louis? Me. Now, there are exceptions to that that can be challenged, but that's the general rule. So if you had $1 million bank account with me and it says I leave everything to Louis and there's only 100,000 in your name, Louis gets the 100,000, I get the million. Now, could he try to challenge that? There are various grounds to do that. We're not going to get into it here. Just know there are exceptions. But as long as your estate planning is consistent, you don't need to worry about the exceptions and fancy lawyering. Just set up things right and things will go the way you want. Okay. So remember, it's used to transfer assets on death in one's name alone. It's not effective until you die. And the will has to be admitted to probate. Well, people ask, what is probate? Right? Well, simply stated, a properly drafted will is submitted to the court with other documents. If everything goes according to the way it's supposed to, the court will then issue what's called letters testamentary. Okay, that gives the named executor the power to act according to the terms of the will. So once again, will has to be drafted properly. It's submitted to the court, and then the court gives you the power to act as executor according to the terms of the will. Well, what does properly drafted mean? Varies from state to state, of course, although pretty similar in most states. Witnessed at the time it's signed by 2 witnesses and attested, something called an attestation clause. All right. Also, there's an affidavit that has to be submitted with the will. And basically, it's an affidavit that says a number of things, that you were there, you witnessed the will, the testator acknowledged it was their will, they signed it in front of you, they signed it in front of the other witness, they were over 18, they were competent. That's what this affidavit says. When can the affidavit be signed? Only 2 times. Within 30 days of the will being signed or when the will is offered for probate. Now, I've gotten many wills in my office that were not drafted by me where the attorney failed to attach the affidavit to the will at the time it was drafted. So you can imagine getting a will from 1992. Okay, who are these witnesses? I don't know. Can't even read their names. All right, so now we got to go, is the lawyer who drafted the will still alive? That's when the probate process becomes, expensive, time-consuming, and stressful. So that's why all my wills, I have my affidavit done. At the time the will is signed, I staple it to the will. Therefore, when the will is admitted to probate, you don't have to go chase witnesses. The only time there's an exception to that, 2 times. 1, the testator dies within 90 days of executing the will, and then the court may want to hear from them. Well, if it's only 90 days, it's not going to be hard to find, right? The other time, if there's a will contest, then they may be called upon to testify. That's it. Will contest, meaning someone is contesting the will, right? So another thing that people ask about is, what if I don't have a will? What happens then? What happens to my money? People say, well, it goes to the state. Can it go to the state of New York or wherever you live? Yes, it can. Will it? Probably not. Why? Because the state generally writes a will for you. It's called the intestacy statute. In New York, our intestacy statute is pretty specific. One thing people don't realize, or find surprising, say one spouse has all the money in their name alone. Now remember, if it's joint, you don't need to probate the will, right? That's what we're talking about. But husband or wife put everything in their name alone, and they die. And they had no will. So what happens? Well, now there's no probate, but you still have to go to the surrogate's court, and you have to file what's called an administration proceeding. Okay? And in the administration proceeding, the people who would get the money under the statute have to be notified. Also, one of them has to petition the court to be the administrator, to do the job that the executor would do if there was a named executor. So you have to have an administrator, someone to petition the court and say, hey, this person died. They have $500,000 in their name alone, and I want a petition to be their administrator. So what does this statute do? Well, people find this unusual, husband and wife situation. The statute provides that the first $50,000 goes to the wife. And if there are children, the children get half and the wife gets half. That's what New York's will, people find that surprising. Well, what if I have no wife? I just have children. Well, they get the money. What if I have no wife and children and my parents are alive? Or parent is alive? Parents get the money, and so on. Brothers and sisters, nieces and nephews. The statute goes out as far as first cousins once removed. Okay, so if you have a first cousin once removed, that's somebody known as a laughing heir, and you had no will, they might end up getting all your money. That's first cousins once removed, is basically the cousin of the child of a first cousin. That's how far they go out. So now the other side of this is, I have people come to me all the time. I am 75 years old. I'm single. I have no children. I have no siblings. All I have is cousins. Say, okay, well, if you do a will, what's going to happen is when you die, these cousins have to be notified. Well, why do they have to be notified? I told you I want to leave it to charity. You can leave it to whomever you want. But the law requires that your cousins be notified. That's what the law, I don't even know where they are. Well, there's a way of getting around that. We'll talk about that in a bit. Let's go back and we'll finish up on wills, okay? So we talked about the probate process. We talked about the will has to be properly drafted and properly witnessed with an attestation clause. Extremely important. And like I said, people have a tough time with this concept. It only controls assets in your name alone, all right? So only with your name on it, that's it, okay? The executor is the person named in the will. They're responsible for gathering the assets, distributing under the will, and they are entitled to commissions, okay? As I said before, these assets, PDF, POD, or, joint tenants or right of survivorship, they don't go through probate and they go where they're designated in those documents. Are there ways of challenging that? Yes, but they're limited. Specific assets, they can be mentioned in the will and given to specific people. Sometimes that makes sense. So you talk about a valuable piece of artwork or something like that. Yeah, it makes sense to do that. Generally, it doesn't. Usually, like I said, it's best to put things in percentage forms. And another thing too, some people leave their assets to charity. One thing you should know about if you're doing this through a will, if you leave a percentage to charity, the Attorney General of the state of New York becomes a necessary party and they have to be cited. So you now have to involve the Attorney General's Charities Bureau if you're leaving a specific percentage of your assets pursuant to will to a charity. So I say either leave them a specific amount of money, okay? But remember, when you leave someone a specific amount of money, they get that money first. So that's also something to consider. How do we avoid these things? We'll get to that in a minute when we talk about trusts. How long does probate take? Well, generally, I tell people approximately a year. They go, a year, why so long? Well, here's the reason why. We have to go through the probate process. And in New York, because of COVID and because of changes in the law that were made before COVID, it now has become very difficult, right? In the past, say you had a spouse and children, nobody was disabled, everybody got along, the kids were adults, so on and so on. You didn't have to worry about estate taxes, which we'll talk about later. You had a fairly simple estate, no property in another state. I would say, you don't need to do anything, just do a will. I don't tell that to people anymore because probate takes a while now. And I will just give you a quick example, okay? I had a number of years ago, before COVID, okay, where it was two children and the mother had predeceased, so everything was going to the two children. One of them is the executor, the kids got along, no problems. Daughter lived, I'm in Westchester County, daughter lived in Suffolk, and she's like, Joe, just send me the papers so I could sign them. I'm like, okay. Sent them to her, and they had to be notarized and acknowledged. An acknowledgement is different than a regular straight notary. So in that acknowledgement, you have to put the state where it was signed and the county. I left it blank because I didn't know if she was going to have it signed in Nassau or Suffolk County. Came back to my office. My associate at the time didn't realize that the notary forgot to put the county in, okay? And she filed it. 4 months later, get an email from the probate clerk. We're rejecting your petition because it wasn't initially, the county wasn't put in. So now I look like a fool, right? I had to call the client up, resend the stuff out, send it back, another 4 months. Whereas say 10 years ago, I would have gone, walked the papers into the clerk's office, sat down with the clerk. Clerk would have looked them over and said, hey, Joe, there's no county here, write the county in. And I would have had letters testamentary in 2 weeks. Now this was before COVID. So now you can imagine the state, basically in New York State particularly, they very short staffed. They didn't bring everybody back in until around Memorial Day this year. So you had a time when nobody was there. Then you had a year when there was very short staffing. You know, a lot more people dying. So the surrogates court is backed up. So when I used to say to people, oh, don't get a trust, now I tell them, I think you should get a trust, okay? So what's a trust? Well, like a will, it's a legal document, okay? And trusts are like Chinese menus. You basically pick what you want in the trust and they're used for different purposes. But the two main distinctions are called testamentary trusts and inter vivos trusts or living trusts. So you could have a will and you could set up a trust within your will that only takes effect after you die and is funded after you die. That's a testamentary trust, okay? What people typically think of to avoid the probate process, which we just discussed, is a revocable living trust, okay? That's typically what people do to avoid the probate process. So you may say to me, as clients have, wait a minute. You're telling me to do a trust, right? Yeah. You're also telling me that I'll avoid probate if I leave everything joint. Yeah. Well, then I won't do a trust. I'll just leave everything joint with my 3 kids. Well, once again, that works assuming your kids don't die before you do. What happens if they do? What happens if one of your children dies before you and now you've named 3 of them joint on your account? Do you want the other 2 to get it, or do you want the predeceased children to get it? Okay. And are you really going to be in a state of mind especially most people wait a long time to do these things? Are you going to be in a state of mind to, oh yeah, I have my joint accounts and now one of my kids died, I got to go back in and fix that. Most people are not in that state of mind. So that's it to my mind. If things go great, according to plan, yeah, that works. But do things always go according to plan? No, they do not. So I say, set up a trust, put all the contingencies in the world in the trust. And you avoid the probate process. Is it more expensive? Well, upfront it is, but on the back end, you save. I think they've done studies. This is before everything went south with COVID, and they said that you save 25% by doing it up front, but obviously now you're paying the money up front. I would say that I would argue that that money amount is a lot more now because of the problems that COVID has caused, and also these financial institutions are making it a lot more difficult to extract the money from them. It used to be you send them a letter with the letter's testamentary and the death certificate, and they send you a check. Well, now it gets rerouted, it gets lost, it gets here, you got to make repeated phone calls, God knows how. It's just become a nightmare process. Way to avoid this is through trusts, okay? And as I said, there are trusts that are part of your will. That's not what we're talking about. We're talking about living trusts or inter vivos trusts. So they are written documents that, like a will, say what's going to happen when you die with your assets. But here's a catch. You have to put the assets in the trust. I've had people walk into me, oh yeah, dad did a trust. Okay, let me see the trust. Well, what assets are titled in the name of the trust? Guy looks at me like I have 9 heads. What are you talking about? Well, did dad take his Merrill Lynch account and have it transferred to the trust? No. Did he go to Chase Bank and have his bank accounts transferred to the trust? No. Well, then take the trust and use it as wallpaper or toilet paper or whatever you want to use it as, because it has no effect because nothing was transferred to it. Okay. So for the trust to be truly effective, assets have to be transferred to it. And really everything has to be transferred to it. And I'll tell you one more horror story. I had a guy from Eastern Europe, and he had a wife, his wife died, no kids. He had a brother died, no kids. So he says, well, I explained this whole thing to him. You really should do a trust. He says, I agree. But you got to put the assets in the trust. He goes, okay. So he had real estate. I transferred the real estate into the trust. He left. He had a couple more $1 million in assets. He probably got $1.5 million of it into the trust before he died. But there's $500,000 that never got in the trust. So what happens with that? What we did to catch this, we also did what's called a pour over will, which basically says, look, if I didn't get my assets in the trust, they're now going to go through the probate process and go into the trust. So some people ask me, if I have a trust, do I need a will? Yes, you do, because people invariably screw this thing up somewhere along the line. And that's what this guy did. Well, P.S., he died right before COVID. The case has been in the court system since COVID, so it's 1.5 years plus. And first cousins, once removed, have come out of the woodwork and now contesting the will and contesting the trust. So God knows when this is going to get wrapped up and these monies are going to be distributed. We don't know because he didn't follow the complete plan. So it's not only drafting the documents, it's when you leave the attorney's office, following up, understanding what you have to do. I just had somebody today, what about this one account? Can I leave it alone? You could do whatever you want. But if the account's in your name when you died, you still got to go through probate. And if it's under 50, if it's over $50,000 in your name, they have to go through the whole process anyway. So why would you want to do that? Once you get everything into the trust and set it up, well, it's like everything else, like you get used to it. It's instead of saying the John Doe bank account, it says now the John Doe Trust number 1 bank account. And as far as you're concerned, there's no difference. You're still writing checks. You have to change all your direct deposits. You have to do all of that. It's a royal pain in the neck. But if you want to make things easier for your family, when you pass on, set up a trust, okay? We talked about testamentary trust only going into effect when you die. Inter vivos trust is set up while you're alive. There are 2 types, revocable and irrevocable. Well, revocable, you could revoke it, you could cancel it, you could change it, you could take money in, take money out, do whatever you want. Then there's irrevocable. Well, why would you do an irrevocable trust? You say, Joe, irrevocable means once I put my money in, I can't get it out. Yep, you can't. Why would I do that? Well, there are a number of reasons. You might do it for Medicaid planning purposes. You might do it for estate tax purposes, beyond the scope of what we're talking about here, but there are many reasons to do irrevocable trusts. Once again, drafting and signing the document is not enough. You got to get assets into it. The trustee is the person who handles the trust. As we mentioned, the executor in a will, the administration and administration proceeding. We have the trustee for the trust. If it's a revocable trust, can you be a trustee? Absolutely. You're the trustee. Most times I recommend naming a co-trustee, but some people don't feel comfortable with that for the same reason of naming a power of attorney. I recommend naming a co-trustee. They don't have to do anything, but they can. And definitely name successor trustees. With an irrevocable trust, generally you are not the trustee. You name a third party for various reasons, taxes, other reasons. So people also say, well, wait a minute, if I name a third party as trustee, what if they go bankrupt? It's not their assets. They're holding it as trustee. It doesn't go in their bankruptcy estate. Can't be attacked by their wife in a divorce. They're acting as trustee. Okay? The basic, simple living trust, it's a revocable trust. It's commonly known as the living trust, is used to avoid the probate process. That's basic enough for most people. If you have estate tax issues, if you want to do Medicaid planning to avoid, qualify for Medicaid in case you need a nursing home, then we use other things. So it says here, what? Medicaid planning, estate tax planning, probate avoidance. Those are generally the reasons for using a trust. Okay. So they could be they could be customized to fit your individual needs. So whatever you want to do, we'll do. It's funny. People are funny. I just had a lady in yesterday who says, I want to do a basic trust. And she explained to me that some of the people she wanted to use it for were under 10 years old. Well, what do you want to do? When do you want them to get this money? Well, she gave me this whole complicated thing as what she wants to do. Well, it's obvious for me to write those provisions going to cost you more money. It's not a basic trust. She got upset. Well, you told me your price. Yeah, I told you price for a basic trust. But now we're not talking about a basic trust anymore. We're talking about complicated provisions to protect minors and utilization of money for minors. So obviously that adds to the expense. So you want something customized, then it's going to cost you more. Understand that. Okay. What do I mean by Medicaid planning? Okay. Well, what's the goal? The goal is to get the best possible care, all right, and get the most government benefits while protecting your assets. That's the goal. When people come in for Medicaid planning, they want to do that. Now, do you need Medicaid planning? Well, what's the deal? Today in this area, okay, nursing homes cost anywhere between $10,000 and $25,000 a month. Okay. Now, if you have assets and pensions and Social Security throwing off that kind of income, then you don't really need Medicaid planning. People say, I want to protect my income. Well, you can't, right? Anybody who qualifies for Medicaid in an institution, nursing home, they're only allowed $50 a month in income. So we're not talking about income protection for Medicaid planning for institutional Medicaid. We're talking about asset protection, right? So I want to protect my income. I'm going in, if I go in a nursing home, you can't, okay? You're going to protect your assets. And we'll go into that more in a bit. So what are we talking about here? We're talking about nursing home bills. That's what we're focusing on to start. How are they paid? Well, there's a limited Medicare benefit. There's pay out of your pocket, which is obvious, right? And there's long-term care insurance. And then there's Medicaid, right? So once again, Medicare out of your pocket, long-term care insurance, Medicaid. Medicare. What is Medicare? For those of you who don't know, it's insurance, government health insurance. We all pay into the system. You all are going to qualify for it. When you're 65, you should apply for some portion of it. There are penalties for people who don't, believe it or not, if you don't apply at 65, and that's for another lecture. But what does Medicare cover? Well, first I'll tell you what it doesn't cover. Let's say someone is home and they have Alzheimer's and they have a caregiver who's taking care of them. And suddenly the caregiver can no longer care for them. And that person, they have no other problems other than they have dementia and they cannot handle their daily activities of living, right? They can't feed themselves, clothe themselves, bathe themselves, but they're otherwise healthy. That person now has to go to a nursing home. What does Medicare cover? Zero, nothing, zilch, okay? Medicare is very specific in what it covers. Number one, you have to be discharged after at least a 3-day stay in a hospital, okay? Number two, you have to be going somewhere for rehabilitation, okay? Very important. 3-day hospital stay going for rehabilitation. Classic situation, person has Medicare, they fall, they break their hip, they go in for hip surgery, they go in the nursing home for rehab. Let's say they're otherwise fine. Once rehab ends, they say, okay, well, you're not benefiting anymore from rehab. They discharge them home. But let's say that same person now, they can no longer feed themselves, clothe themselves, bathe themselves. What happens? Medicare will not cover them anymore. That's when one of the other three options kicks in: long-term care, Medicaid, or out of your pocket. Let's talk what Medicare does cover when it does cover something, okay? First 20 days are in full. There's another potential 80 days, so the maximum coverage is 100 days. There's a copay of $176 a day. But remember, the maximum benefit is 100 days. If they deem you are no longer benefiting from rehab, they cut you off, all right? Some supplemental insurance plans will cover that part or all of that Medicare copay of $176 a day. That's something you should look into, your own health insurance. Are they covering that? So that's basically all that Medicare covers, and it's very limited. Paying out of your pocket, well, that's self-explanatory. You're paying out of your pocket. Long-term care insurance. Well, they're issued by private companies. New York State has this public-private partnership thing you could look into. It's decent rates. New York provides a deduction if you are paying premiums on one of these policies. It's capped at $1,500 a year. This is just New York State returns, not federal returns. And your AGI, adjusted gross income, has to be less than $250,000. Then you'll get a deduction. Some or all of your premiums up to $1,500 a year will be deducted. Okay. Now, what is Medicaid? It's a government program where only indigent are covered. All right. There's community-based Medicaid and institutional-based Medicaid. We're not really going to focus much on, because of time constraints here, already almost an hour up. We're not really focus on it, but New York changed the rules in October. They've now imposed a penalty period of 2.5 years. We'll talk about that when we talk about institutional Medicaid. So just know it's available, but there are very limited income levels and asset levels on that. All right. So now we're talking about the person who, let's paint the picture. Single person, discharged from a hospital. They go for rehab. They're getting Medicare coverage. Rehab expires. Medicare is cut off. They don't have any money. They go on Medicaid. Well, how do you go on Medicaid? What assets are you allowed? All right. And you're going to hear that the asset limit is pretty low. You say, well, I have more than that. How do I plan for it? Well, there are ways of, if you do it far enough in advance, or believe it or not, even if you do it at the last minute, there are ways of getting some Medicare coverage for you. That's if you come out with nothing else. Remember, don't think that, oh, mom's at a nursing home. She's been there for 3 months. Nothing I can do. There may be something you can do. There may be something you can do to protect mom's assets. Always don't think it's too late. It may not be. It doesn't hurt to have a consultation with a medic person who's an elder law attorney who knows what they're doing. I will tell you though, in other states, New Jersey, for example, that they're not anywhere near as flexible in New York. New York has very liberal rules, okay? And let's just briefly explain what Medicaid is. It's a federal, state, and local partnership program when it comes to funding, okay? In New York, it's paid 1/3 by the federal government, 1/3 by the state, 1/3 by the county or in the case of New York City, by New York City. And also the federal statute basically offers the states options, okay? You could pick option A, you could pick option B. I will tell you that New York State has picked the legislation as the most liberal option, meaning the most opportunities for planning. All right, some states like New Jersey don't have as many opportunities for planning. You really have to plan more than 5 years in advance, and I will explain why in a minute, okay? So what I'm gonna explain to you now, what I just told you about Medicare is national. It applies across the country because Medicare is national. Medicaid varies from state to state. I'm going to focus specifically on New York law when I'm talking about Medicaid, right? So best way to start is, how do you become eligible for Medicaid? Well, you can't have assets, liquid assets, more than $15,900 in your name. And we're talking right now, institutional Medicaid, you're in a nursing home. You're only allowed $50 a month in income. But there are certain assets that are exempt. Well, in addition to this $15,900, what's exempt? Well, $1,500 burial fund, or better yet, you could prepay your funeral expenses, something everyone should do. Go to funeral home. It's called the New York Medicaid pre-plan. Not going to go into that in depth. You can pay your expenses. What people try to do is, well, my funeral's, I bought the plot. The funeral itself is probably going to cost $15,000. I'm going to spend $40,000, and then when I die, my kids can get the rest other than what's spent. No, it doesn't work. Basically, if there's that money left, it goes back to New York State. So you prepay your funeral expenses, and the money is taken care of. So people say, well, all I have is $65,000. Well, might as well prepay your funeral expenses now. And there's other ways of getting down to the 15.9, which we could discuss. Not really the subject here, but there's different planning techniques. Just if you leave with nothing else, know that there are planning techniques. Know that the best time to do it is 5 years in advance of needing nursing home coverage, need nursing home care. You could do it anywhere along the lines. Even after you get in a nursing home, just keep that in mind and consult with an attorney if you find yourself or a close family member in that position. But the better you plan, the earlier you plan, the better, okay? Now, you're allowed 1,500 buried fund. We talked about that. And you're allowed equity in your home of up to $906,000, okay? And you're also allowed an IRA. So I'll give you a little quiz. Let's say someone has prepaid their funeral expenses. They bought their plot. They spent $30,000 on that. They have $1 million IRA, and they have a house worth $800,000. Now they fall, break their hip. They're single. They have to go to a nursing home. Can they get Medicaid benefits? The answer is yes, because they have these exempt assets. But it's a little bit of a catch. Remember, I told you it's $50 a month in income. So the IRA has to be in payout status, and they pay it out according to your life expectancy. So if you're getting $100,000 a year payout on your IRA, that's going to the nursing home. And basically, Medicaid will cover anything above that. So they'll cover like your pension, your Social Security, whatever it is. All of that goes to the nursing home, and Medicaid picks up the difference. Okay. Well, remember I mentioned the house is exempt. There's an assumption in New York, and by the way, once again, this is New York centric. Not all states have this. That it's assumed you're going to return home. What if the person has Alzheimer's and they can't walk? Well, they very liberally construe this. They make legal fiction. Yep, we assume they're going to return home. So I tell the family, look, if I were you, if I could keep the house up, keep it. And when the person passes away, sell it. The Medicaid, the one thing though, Medicaid can file a lien against this house. So why wouldn't I just sell it if they're going to file a lien? Well, here's the reason why. In New York State pays at least 70% of the nursing home bills. And what they do is they go in and they negotiate with the nursing homes. They say, okay, nursing home, you're charging private pay rate 15 grand a month. We're not paying you that. Typically, they negotiate a rate of 2/3 of the private pay rate. So they're paying 10,000. So as you could see, let's say we follow my scenario. The person goes into the nursing home and they qualify for Medicaid. Medicaid pays for 10 months, then they pass away. And if the house was not put in a trust, it has to go through their estate. Medicaid will file a lien. But notice if it was private pay, they would have been paying 150,000. Now the state only has to pay back 100,000 because Medicaid covered it. So this is it's a good thing. It's a tool to be utilized. Some families can't afford that. We can't carry the house. Well, they just have to sell it and we'll have to do some other type of planning. But keep that in mind. There's some exemptions. If you're married, we'll talk about marriage situation in a minute. You could transfer your house to your wife and they can't put a lien on it, or your husband, as the case may be. If there's a child living in the house with you and qualifies as a caretaker child within the meaning of the law, you could transfer the house to them and there's no lien. Okay? So these are all planning techniques we'd go over. And remember we talked about the look back period. Well, what do? If you're applying for Medicaid, they want 5 years with the bank statements, okay? And everything. Life insurance statements, bank statements, tax returns, everything. So people who throw out this stuff, don't. Keep it for at least 5 years. Or have access to it online if you don't keep it. Because they're going to want that. They want 5 years worth of everything. And typically it depends on the county, but they're going to look at any transfers over $2,000. Say, well, you know what? I pay my property taxes every year. And we know in New York, your property taxes can be anywhere from $10,000 to $55,000, $60,000, $70,000. Well, that's fine. That's not an uncompensated transfer, but you have to provide proof. Here's the canceled check to the taxing authority, and here's my tax bill. Fine, no problem. What they're looking at is uncompensated transfers. But remember, any transfer, some counties 2,000, some counties 3,000, they're going to look at. And by the way, if it's under 2,000 or 3,000, if they see a continuing pattern every month, they may ask for that backup if it's under their normal limit. But you have to have the backup. So things you shouldn't do, pay caregivers cash, pay contractors and people doing work on your house cash. You want to have bills, you want to have receipts, you want to have everything, right? Do everything if you want to back up your expenses, do it by check, do it by credit card, have the receipts, right? Because if not, they're going to assume that this is an uncompensated transfer and you get a penalty. What's the penalty? Okay, well, let's say, we'll go down to my example here. There's a perfect way to do it, okay? Let's assume there was a gift of $130,000. People think of gift tax exemptions, you give 15, nothing to do with that. You gave a gift of $130,000 over 5 years to one of your kids, okay? They're able to go, okay, over 5 years, you gave them $130,000. They're gonna say, and you live in New York City. New York City, they're gonna use the number of $13,037. They're gonna take $130,370 divided by this, they're gonna come up with a 10-month penalty period. So what it means is no Medicaid for you for 10 months. After 10 months, the Medicaid will kick in, all right? So that's how they calculate it. Now there's different rules with married couples. I shouldn't say different rules because the same rules I just said apply. However, the married person in New York, they're allowed money. They're allowed additional income for a little under $3,300. They're allowed to keep up to $130,000. And they could file something called a spousal refusal. And if they file a spousal refusal, it's just, I'm not supporting my spouse. That's all it is. Then Medicaid must provide benefits to the spouse in the nursing home, and they can come after the spouse at home, but they have to provide benefits, okay? And remember, we talked about this penalty period. There's no transfer penalty period between spouses. So you could transfer stuff to your wife the day before you have to file a Medicaid application. It's fine, okay? And we said there's like that exemption too on penalty for transferring to a caretaker child. So one other one of a house. Well, my son lives in Connecticut. I live in the Bronx. No good. My son lives in the second floor of a 3-family house. Great. You can transfer the son to your house. The house to your son, not the son to your house. Your house, the house to your son. You're allowed to do that. Okay. So these are ways of getting this. Once again, like I said, you could probably imagine it gets very complicated. So how do we protect the house? Well, one recommendation, 5 years in advance, set up what's called a Medicaid Trust. Put your assets, all of them in a Medicaid Trust after 5 years, because remember, they don't look back more than 5 years. The assets are protected. What's the catch? The trust is irrevocable. You can't take anything out. Some attorneys draft those trusts with a back door, which allows the trustee to go in and pay it to third parties. I refuse to do that because those trusts are under strict scrutiny. And also, people usually abuse that. So it becomes a waste of time. So I refuse to draft them like that. But some attorneys do. Now, some people do something called a life estate. I don't recommend that. I, once again, suggest using a Medicaid trust as opposed to a life estate. We're going to kind of blow through this kind of quickly because we're running over at this point. So protect your house, okay? Know about step up in basis. You want somebody to get it. You don't want to give, people give the houses away to their kids. Bad idea. If you bought your house for $40,000 and now it's worth $400,000, and let's say you put $100,000 into the house, just your basis in the house is $140. If you give it to your kid, their basis is $140. If they inherited from you, their basis comes a step up in basis, meaning the fair market value on date of death. So if you give it to them and your basis is $140 and they sell it for $640, they have a $500,000 gain. All right. If you give it to them on the date of death, and they get it as a result of your passing, either through a trust or your will or whatever, then their basis becomes $600,000, your value on date of death. And if they sell it for $640, their gain is only $40. So very important to understand these basis rules. I've seen plenty of people come in here, gone to attorneys, they don't understand the tax issues, don't understand the elder law issues. They just transfer it out. Not necessarily a good idea. Every circumstance is different. So you have to consult with someone who knows what they're doing, and you have to give them complete facts and information, okay? Some people want to provide for their grandchildren's education. There are 529 plans, college savings plans, there are UTMA plans, there are trusts for grandchildren. Once again, giving gifts can potentially be a problem because the gifts are assumed to be for Medicaid planning purposes. It could be brought back in. Not necessarily a grand idea, but once again, that's a subject of more detailed consultation and discussion. What's an estate tax? Well, the government basically takes a snapshot of what you're worth and they impose a tax. For most people, the tax doesn't matter anymore because for federal reasons, you'll see here, federal tax, you have to have $11,700,000 before they impose a tax on your estate for federal purposes. Double that for spouses. And they make it pretty easy. So say you never did any tax planning and then the first spouse dies and you go, oh my God, we have $20 million. Well, the second spouse still has a way of getting around the first spouse's failure to plan. That doesn't necessarily apply on the state level. Now, some states like Florida don't have a state tax, so you don't have to worry about it. But New York does. And New York estate tax kicks in when one has an estate of $5,930,000. So I tell anybody when they're over $5 million, you should really start doing some estate tax planning. You have to assume that your value of your assets are going to go up over time. And if you're coming into me and you haven't come into me for a while, that might as well do some estate tax planning now. Okay. New York exemption has a cliff tax. Basically, that means it goes up pretty quickly. So you'll notice on this little chart, I know it didn't come out too clearly. See if I could blow it up a little bit. No, I can't. But if you have a $5,930,000 estate, no estate tax. But you go up to $6,100,000 estate, your taxes basically 381,000. So it's something, it's not insignificant in New York. You have to plan for it. Other states have similar taxes in the Northeast and other parts of the country. A lot of the southern states like Florida do not, or they have a lot less tax. Okay. People get confused with gift taxes too. Okay. The gift tax and the estate tax are unified because what people would do is say, I'm going to avoid the estate tax by giving my money away. Well, they said, we're not going to do that. We're not going to allow that. So if you gave money away during life, well, it's going to affect you. There is an annual exclusion. It's indexed for inflation. Right now, it's $15,000. So you can give someone $15,000 and it's not going to affect your estate or gift tax issues. But let's say, and you and your wife, if you have a marriage, that could be $30,000 to the same person, right? But let's say you give $115,000 to the same person in the same year. This is an annual thing, okay? So you give $115,000 to the same person in the same year. So you're $100,000 over the annual exclusion. What happens? Okay. Well, if you look at the numbers again, 15,000 is your exclusion. You're now over that. Remember, we said that up here, they don't bother with your federal estate until you're 11.7. Well, now since you've given during your life 100,000, it now goes down to 11.6. For most people, does that matter? No. For people, but New York, same thing. They'll drop you to 5.8 instead of 5.9. So that's how giving more than the annual exclusion affects your gift taxes. If you're under $6 million or in New York State, or if you're under 11.7 and lives in a state with no estate tax, the gift tax is irrelevant. Don't even think about that $15,000 exclusion. It means nothing to you. Okay. So one thing about New York does not have a gift tax, but it does have a clawback. What does that mean? Let's say whether you know you're going to die or not, but some people might do this as a planning tool. Gee, I have $7 million, so I'm going to be subject to yes. The recommendation is if you move to a new state, get a new will. Do you have to? No, but you really should. No, you really should. Just makes it easier for the administration of your estate. Okay. The fellow alum told me that the owner offers will services. Well, I don't know about that. You have to talk to the Alumni Association. Let me see. There was a Q&A on the same thing. All right. So there was only one question. Okay. So that's it for me. I don't know if anybody has any other questions they want to put in the chat or anything else.
Well, as we said before, we will be sharing the outline with everyone. So, that will go out to the email that you registered with. So we will get that done probably in the next day or two. I already have that. So if there's no other questions, I do want to say thank you so much, Joe, for a very thorough presentation and a lot of useful information. And also, thank you to everybody for joining us and getting the lowdown on the documents you should have and how they work. Just a reminder, the next seminar is a long who wants it. Okay. So again, thank you so much for joining us, Joe. I can't thank you enough for,
You're very welcome, Steve.
starting us off here. And with that, I'd like to wish you all a good day.